Welcome to Outside Views. Today we continue our deep dive into what it would actually mean for the United Kingdom to apply for EU membership again. And just to make it clear, this is not a rejoin. There is no automatic way back. There's only the accession process. And as we have discussed before, this process is the same for every country that applies. And today we will examine one of the most crucial and challenging chapters of the EU accession process, that's judiciary and fundamental rights. And this is one of the core areas that defines whether a country meets the EU standards on democracy, on the rule of law, and on human rights. And it's also one of the areas where the UK has diverged the most since Brexit. If the UK were to reapply for membership, it would need to fully comply with the EU's requirements in this chapter. And, like all other chapters, this is not a negotiation, although it's called that. There are no opt-outs, no special treatment, no cherry-picking. Only full alignment with EU principles. So what does this chapter actually cover? The EU's judicial and fundamental rights policies are designed to maintain and further develop the Union as an area of freedom, security and justice. A fully independent, efficient and impartial judiciary is a fundamental requirement. Member states must ensure that courts operate free from external influence. The judiciary must be properly funded and judges must be trained to uphold the highest standards of integrity and professionalism. Legal guarantees for fair trial procedures must be in place, and equally important is the fight against corruption. Corruption threatens the stability of democratic institutions and undermines the rule of law. For this reason, the EU requires candidate countries to have a robust anti-corruption framework. And this means independent institutions that prevent and prosecute corruption, legal mechanisms for whistleblower protection, and strict financial transparency in public contracts. The UK, before Brexit, had strong anti-corruption measures, but recent reports suggest weakening enforcement mechanisms, particularly in public procurement. There have been multiple scandals involving government contracts awarded without competitive bidding. And this would need to be corrected to meet EU standards. Another essential part of this chapter is fundamental rights. The EU requires all member states to fully implement the Fundamental Rights Charter. And this means strict protections for freedom of speech, freedom of assembly, and protection against discrimination. It also includes guarantees for the rights of minorities, data protection and equal access to justice. And post-Brexit, the UK has diverged in several areas. The UK government has sought to limit the influence of the European Convention on Human Rights, and recent legislation has weakened certain civil liberties protections. And this would have to be reversed. The UK would need to fully align its legal framework with EU human rights standards with no exceptions. And one major sticking point would be judicial oversight. The EU requires member states to be under the jurisdiction of the European Court of Justice in areas covered by EU law. Brexit was, in large part, sold on the idea of escaping the ECJ's jurisdiction, but joining again would mean returning to it. British courts would have to apply ECJ rulings where EU law applies, and for Brexiteers that would be politically unacceptable, but for the EU, it is non-negotiable. If the UK wanted to join again, it would have to accept the supremacy of EU law in relevant areas. And another issue is data protection. The EU has strict GDPR regulations that govern how personal data can be collected and used. Post-Brexit, the UK has explored policies that would loosen data protection laws to favor businesses. And this would not be compatible with EU standards. The UK would need to restore full compliance with GDPR and ensure that data transfers between the UK and the EU remain secure under EU rules. And then there's the question of migrants and asylum seekers. The EU has clear rules on how asylum applications must be processed. The UK's current policies, including controversial deportation programs and restriction on asylum claims, would likely not meet EU human rights standards. And these policies would need to be reformed even more than Labour is trying to if the UK wanted to align with EU law. Beyond this, there are deep structural reforms that would be required to demonstrate alignment with EU principles. The independence of regulatory and oversight bodies, protections for journalists and press freedom, and judicial accountability mechanisms would all need to be reassessed. Post-Brexit Britain has faced criticism over the erosion of press freedoms and government influence over regulatory institutions. These concerns would need to be addressed before EU accession could proceed. The legal framework surrounding law enforcement cooperation would also have to be rebuilt. Prior to Brexit, the UK was part of Europol, Eurojust, and other EU-wide law enforcement agencies. Joining again would require full compliance with EU policing standards, including sharing of sensitive criminal data and cooperation on cross-border investigations. Post-Brexit, the UK has had to rely on bilateral agreements, which are far less efficient than the previous EU structures. To join again, full reintegration would be necessary. And this brings us to the broader picture of EU accession. Joining the EU again is not a simple return. It's an entirely new application process, as I said. And that process is governed by the so-called Copenhagen criteria. And these criteria set the fundamental requirements for any country seeking EU membership. A candidate country must demonstrate stable institutions guaranteeing democracy, the rule of law, human rights, and protections for minorities. It must have a functioning market economy capable of handling the competitive pressures of the EU. And it must show the ability to adopt and enforce the full body of EU law, including judiciary and fundamental rights. And many people think of negotiations as two sides bargaining over terms. But EU accession is not that. It's a process of compliance. The EU does not lower its standards for new members. It's the applicant that must meet those standards. And the UK, if it ever were to apply, would not receive special treatment. It would go through the same 35-chapter process as any other applicant. Judiciary and fundamental rights is just one of these chapters. And failure to comply here means failure to progress in the accession process. And this is why the process is long and rigorous. There are no shortcuts, only full compliance. And joining the EU again means fully aligning with EU judicial independence, anti-corruption policies, and fundamental rights protections. There would be no opt-outs, no exceptions, no cherry-picking, no unicorns, only the process. And given the UK's current political climate, achieving compliance with this chapter could be one of the most challenging hurdles in the entire accession process. It would require political will, it would require legislative reform, and a commitment to European values that has been absent in much of the UK's post-Brexit governance. So thank you for watching Outside Views, and if you found this analysis insightful, don't forget to like and subscribe. And let me know in the comments what you think about this aspect of a potential UK application. See you in the next video, and the next video is already right here in the end screen.